Alex, Clayton, and myself are back to field some of the questions that we received for our Stump the Panel session. We've gotten some really good questions, one of which may have stumped us, spoiler alert, but stay tuned. So to get us started, one of the questions we received related to the presentation that Tara and Amanda gave this morning. The question relates to staff that are working from home, staff may be located in a different state, and this particular audience member was asking for some guidance with respect to the legal consequences with respect to staff working from home when they may be in a different state. So Amanda, do you want to provide a little insight on that one?
Yeah, I'm happy to provide the insight on that one, and I will do the full disclosure. I utilized Tara Everline, our employment lawyer, so this comes from an employment law perspective, not from a healthcare perspective on this one. And that the short answer is that the employee may be required to pay state taxes in a state in which they live. So if they're actually residing in the different state, and in such cases, depending on the employee status, that employer may be bound by wage payment discrimination and other laws of that state in which they are residing and now working. So it's actually, frankly, a very complex question that probably could spend a whole discussion on, but certainly if you have employees that have changed their residency to another state, you're going to want to be aware of that and consider those potential implications.
Right. Thanks, Amanda. We also got a question related to 340B pharmacies. So this is the question. We've got a federally qualified health center in town with a 340B pharmacy, and we aren't allowed to send prescriptions over there for patients who are being cared for jointly. Why? Alex, do you want to comment on that?
Yeah, yes. So I would have a few follow-up questions about that. But I think generally, I'm assuming that what we have is a federally qualified health center that's a 340B covered entity. And then we have another entity, practice group or something that's not a 340B entity. And the question is, we have patients who are seen both in the FQHC and in the practice group. Maybe referrals are kind of going back and forth, and can we send patients to their pharmacy, and will those prescriptions, when they're filled, be considered 340B prescriptions? And the standard there is whether the 340B covered entity, in this case the FQHC, is ultimately responsible for the patient's care. If the FQHC referred a patient to a physician group or another entity for specific physician services, and that physician was under contract with the FQHC, was an employee or provided services, and then HRSA would still consider that person to be controlled by the 340B, and the care would still be provided by the 340B covered entity. So that, I think, would be the test. Who is controlling the care at issue? But there's some kind of follow-up questions, but at a high level, that's really the question: who controls the care?
Thanks, Alex. The next question is sort of a two-part question that I think Clayton and Alex are going to tackle together. And this question came out of the panel discussion we had this morning related to the corporate practice of medicine doctrine and some of the comments that Stan and Clayton made this morning. So here are the questions. One, are you aware of any legislation that has been introduced recently, or is it planned to be introduced to repeal the corporate practice of medicine doctrine? And two, do you believe, and the person in the audience that raises this question realizes he's asking us to look into our crystal ball here. But is it more likely for the doctrine to get repealed, or in particular in light of the shift from fee-for-service to value-based care? So Clayton, you want to take the first question?
Yep. Thank you, Brooke. With regard to the first question, to me, as far as I'm aware, the most recent attempt from the legislature to amend in any way the corporate practice of medicine doctrine would have been back in 2019, where they carved out two very narrow exceptions, one dealing with the, basically it's large employers providing on-site services to their own employees. And then there's also a carve out for sickness or sick accident insurance providers, which add to the three existing exceptions, which were the hospital, ASC, and then the PC exception. So to me, going back to the case that I actually had, CCI, I actually argued there in a footnote that the fact that the legislature had not amended or made the exception go away after the Hattasol decision, which this 2009 legislature change would have come on the heels of. I think that's a pretty good indication that at this point, the legislature doesn't have an appetite to do away with this doctrine. And now it seems like with each passing year, it becomes potentially even more stronger just because it's part of our system. Additionally, as far as the courts kind of undoing what it did back in 1924, in light of Judge Broom's recent decision in the federal courts, I think the path to getting that done is going to have to be in the state courts. So I think at this point, I'm not aware of the legislature attempt, and I think from the court standpoint, there could be some hurdles in order to get it back in front of the Kansas Supreme Court. So I think at this point, it seems fairly entrenched.
Alex, do you have anything you want to add to that with respect to just kind of the value-based care component?
Yeah. Well, I guess I'd first say I agree with Clayton. I wouldn't hold your breath on legislative action. I mean, I remember 2019, there was a lot of discussion about what this might look like. We had some optimism that maybe we were going to get a full repeal or a real meaningful limitation of the doctrine, and we didn't really. I mean, not for normal people anyway. So there was a provision that benefited Cerner and Blue Cross Blue Shield and large employers, but not that would have benefited, a smaller venture that might have not the kind of corporate practice issues that we deal with on a day-to-day basis. They didn't make a big dent in it. And I haven't heard of this new legislative effort, but I'm skeptical, I guess. I'll believe it when I see it. There's definitely some interest that are opposed to it, doing away with the doctrine. On the value-based care, I mean, I agree that a movement toward value-based care seems like it would undermine the argument for the corporate practice of medicine doctrine, which is essentially that I think the real concern underlying the corporate practice of medicine doctrine is we don't want outside for-profit businesses in particular controlling how physicians provide care and how they make referrals and all that. And if we move to a system where you're compensated based on quality of care and on cost containment and that kind of thing, then I think it does, as opposed to like a straight fee-for-service model, I think it does kind of, to my mind, mitigate some of the risks that we maybe originally instituted the corporate practice of medicine to address. Yeah, I mean, we're a long way from fully moving to value-based care, obviously, but maybe this will be one thing that will help kind of justify moving away from the corporate practice doctrine.
Thanks, Alex. The next question we have is a HIPAA question, so I'm actually going to take this. So the question, what is the HIPAA interpretation if the spouse of a deceased patient that has PHI approval on file wants lab results? No litigation's been mentioned at this point. So I think I'd have a couple responses to this particular question. First off, typically when a patient dies, a DPOA or a patient consent is no longer valid. But that doesn't necessarily mean that we can't provide access to the spouse for those lab results. One potential HIPAA exception would apply here and that's the exception related to family members being involved in an individual's care. I, of course, would need more facts to know that if it would apply to this particular situation, but generally speaking, the exception applies when the family member has been involved in the patient's care. So if this particular patient had been hospitalized for a period of time, a couple weeks, the spouse was up there visiting as much as the COVID parameters would permit, was engaged in dialogue with the healthcare team, clearly was part of the discussions, and the patient was comfortable with the spouse being a part of those discussions, then you probably could rely on that exception to release the lab results to the spouse. The fallback, for me, the fallback is always just relying on the state law next of kin, kind of the line of succession. If all else fails, we don't have litigation, we don't have an administrator, we don't have letters testamentary in place, and this person really needs access to the information, I will go ahead and fall back on the next of kin. And typically what we recommend there is just to have the spouse, the family member, sign an affidavit attesting to the fact that they're essentially the next of kin to the deceased individual. And then we go ahead and release the information.
And Brooke, if I can interject real quick too, for those of you in Missouri on that point, there is a Missouri statute that if you have a surviving spouse affidavit, you have to disclose those medical records on a surviving spouse affidavit, which is just a small quirk in the Missouri world.
Thanks. Yeah, thanks, Amanda, for sharing that. And so I think the next couple questions actually came out of the Tara and the Amanda presentation. And I think these two are related. One question was related to tracking negative employee tests on a spreadsheet or for documentation, or are you only required to document, the way I understand this, positive employees? And then there was a question tied to that, whether ASCs were exempt from the reporting obligation. So Amanda, can you kind of tackle those two?
Yeah, so the first one, whether ASCs are still exempt from this reporting, came in while I was talking about the COVID HCP vaccination coverage measure, in which different facilities have to go into that CDC website to report vaccination measures, and kind of my speculation that maybe CMS will use that particular reporting measure to require or as part of the COVID-19 vaccine mandate and the reporting. ASCs, inpatient psychiatric facilities, outpatient dialysis facilities are not required to report HCP influenza vaccination summary data and COVID-19 vaccination summary data through that NHSN. Can we get any more acronyms in one sentence? Beginning in 2018. So that's kind of where that question, I think, came from, is that they are not required to report. But as with anything, please remember that just because you're not required to do so, that doesn't mean you don't have to. You're welcome to, according to CMS and CDC, or more than welcome to report that information. And as a quick reminder, the vaccination mandate is going to apply, at least according to what we know from CMS, is going to apply to ASCs. So, while you may currently be not required to report under that vaccine coverage measure, if CMS does decide to go that route of using that already existing measure, you're going to have to start reporting under it. So, and then at that point, it's probably just going to be related to COVID vaccines and not necessarily influenza vaccines. So again, to be determined there. The other question about tracking negative employee tests on a spreadsheet and documenting only positive or positive and negative, to the extent you're asking about that vaccination measure and reporting through the NHSN, you are not required to report any testing in that measure. It is only vaccinations. But to the extent you are tracking testing, there's no requirement that you keep track of your negative employees, but it might be a good practice to do so if, maybe they don't test positive one week, but they do next week. You can maybe kind of start to narrow down what happened or who may have been exposed during that time frame. And so it could just be a good way of being able to verify and not question, oh, well, they weren't really on this list from a week ago, but they have tested, they have tested positive now. It could be useful to keep track of those negative employees.
Thanks, Amanda. I think we're going to pivot. Oh, it looks like we have a polling question that just popped up. I don't know that we are going to have a code for everybody to type in since we don't have slides. But if you don't see the polling question, just make sure you reply in the chat that you're still on and listening. So I think now we'll pivot to some fair market value-based care questions, Alex. We got kind of three that seem to be related, some comments with respect to value-based care and delays in treatment and effective medications, also related to the making of referrals. And I think that the question we got specifically stems from a facility that's in Kansas. There's usually only one hospital in the area providing imaging, lab, surgical care, et cetera. For example, we need 100% of our imaging to the hospital. We are paid for call coverage the same every month. Alex, did you comment? So I think they're just trying to get an idea with respect to the fair market value. When you're in a situation where you have to send everybody, to the hospital, how do you make sure that you can maintain that fair market value relationship?
Yeah, so a few things there. I agree. I definitely agree that value-based care is not a panacea. It's not a one size kind of fits all solution to every problem with our healthcare system. The questioner kind of identified one of the concerns you might have about moving away from fee-for-service into a value-based care that model that incentivized like cost containment. You might have incentives to a provider now doesn't have an incentive to not perform medically necessary care, but if you had incentive to control costs, then maybe you would. But I do think as we view value-based care and try to think through what models might work moving forward, I mean you're going to want the providers to have risk that's based on quality of care, that's based on patient health outcomes. If comp is tied to patient health outcomes, then the providers don't have an incentive to defer medically necessary care. They have an incentive to do preventative care and that kind of thing to prevent bad health outcomes that they might be financially on the hook for. So I mean that's really the key, I think, is building in the right kind of risk into your value-based care models. So I think on the imaging arrangement, or having only one option for places to send referrals, and that's a big issue. I mean, from a START compliance perspective, the key is always having an arrangement. You can have a referral, one source for most of your referrals, and you can have a financial relationship with the referral, that recipient of your referrals. But the key is, making sure that you have that arrangement, that call coverage arrangement, or whether services arrangement complies with an applicable exception. And that would be the personal services exception. And so we need a commercially reasonable arrangement in writing, and that's really the key. It's not that if you can't make referrals, there's not a per se prohibition on referrals. It's just making sure that you fit within an applicable exception.
And then I guess kind of a carry on to that, Alex, would be related to this other question we have, that it's a rural hospital. They're having staffing shortages. And so it's essentially a bidding war right now to get nurses, to get mid-levels, to get physicians. And how do you address that from a fair market value standpoint?
Yeah, it's tricky. We've gotten a lot of questions along this vein, especially in the last few months. Typically we like to look not necessarily as the final word, but we like to look at the survey data, and the survey data is less reliable when we have huge shortages. It doesn't necessarily reflect fair market value. I mean, fair market value does take into consideration, it's supply and demand. Demand is really low, or supply is really low and demand is really high. It makes sense that fair market value is going to increase. Like the new guidance says, I mean, it's arm's length bargaining between, sophisticated parties that don't have any referral relationship, but that's what the standard is. And so, I mean, I think it's key to kind of document, to the best of your ability, document the circumstances that you're in, document your efforts to find coverage, document what you're having to pay for locums coverage or call coverage or whatever. You want to be able to show, you want to be able to support whatever claim of fair market value that you're making. Again, I don't have a perfect solution because it is difficult in these times where we can't look back to historical data because the circumstances have changed so much.
Thanks, Alex. I think this next question will be directed to you and to Clayton. So this is kind of a lengthy question. It gets into the provider relief funds and the reporting and some of the fraud and abuse enforcement that Clayton and Gary presented on this afternoon. So here's the question, or statement that ends in a question. As you know, hospitals receive significant funding from provider relief funds for COVID-related expenses. For money received in the second quarter of 2020, the deadline for spending this was June 30, 2021, with reporting requirement deadline of September 30, 2021, plus a 60-day grace period for reporting. This grace period does not apply to the deadline for spending the money. Subsequent to hospitals receiving these significant amounts of money, the requirements have changed multiple times. At one point, the Kansas Hospital Association had counted 6 changes, and more have happened since then. Most recently, additional changes were communicated through FAQs with an August 30, 2021 date that in some instances caused significant changes as to what is allowed. The troublesome part of this is having rules change after the deadline for spending the money can cause money to be owed back to the federal government. Clayton, do you want to comment on that?
Sure. Thank you, Brooke. 2 things that I really wanted to say about this question, and I guess ones that are similar to it. The first would be sort of as we're experiencing these things real time. What I would encourage folks to do would be proactive. Obviously, presumably, at some point we had a good faith basis to believe that we were entitled to get this money and to spend this money. And it sounds like subsequent to that, the requirements had changed. And so I would want to be tracking sort of what my basis was for believing that this satisfied or was tied to one of the requirements in question or that was applicable. So as we're doing this and realizing real time that these changes are occurring, I would recommend that we're tracking this and we're linking up where this appropriation is going to whatever condition that we believe that this would satisfy. Because it sounds like, and I imagine that as we continue to go, there will be additional guidance because as far as I'm aware, there's really sort of 3 different bodies that folks have been going to, all of which in my estimation are what we refer to as sub-regulatory guidance, which we discussed earlier today. The terms and conditions, the FAQs, the reporting requirements, I believe that's all been issued without any sort of formal notice and comment rulemaking process. And as a result, it goes back to the AZAR decision that I discussed this morning and asking ourselves, do these guidance documents that are being issued by the regulators, do they constitute a substantive legal standard? And if they do, somewhere down the road, if this actually were to be manifest itself in a False Claims Act, I think we have a very strong claim or a defense there potentially to defend on the ground that you can't base a standard on. The real rub's going to be, as I alluded to earlier, is going to be, are they just basically articulating an interpretation of a well-established norm that's been basically established by either a statute or a properly promulgated rule or regulation? And so to me, the standard is how closely moored are these requirements to what's set forth in the statute and the regulation? And then sort of the very last point that I would make is, again, Gary and I typically deal in the FCA arena. And the FCA, the False Claims Act, has what we call a scienter requirement, which is a knowledge requirement. And so at the end of the day, if we're documenting, we're tracking, we're setting forth our rationale, maybe we started this project, it wasn't able to be finished based on, at least within the time frame in which the the new terms and conditions are being set forth, we can, at a minimum, it would seem to me we have a strong argument to make that we were acting in good faith, and it was not one where we had sort of this guilty scienter. So again, at this point, what I think on a day-to-day basis, I would make sure that we're tracking, where if we're seeing new guidance come out, that we're comparing that to what we're already doing and seeing how does this augment or change what we're doing? Do we foresee this changing down the road? And documenting that now, with the expectation that some point down the road, a regulator may come to us and say, how is this consistent with what the requirements were? And it's more than just simply saying, well, they changed. We can articulate how they changed and how that impacted our thinking about that project.
Thanks, Clayton. I think those are all really good points. I know we had, in the last 18 months or so, we had probably at least a half a dozen different hospitals that we were working through that guidance on. And the one thing that we encouraged all the hospitals to do is print a then existing copy of all these frequently asked questions in the event they would later change. Early on in the process, they weren't even dated. You couldn't even tell. Each little entry was dated, but you couldn't tell the date of the actual document. Later on in the process, they did get better with actually putting a date kind of in the bottom left-hand corner. So then you knew it had been updated on August 31st or whatever date it would be. But it's not like they put together a red line document to show you all the different changes. It was just, here's the kind of the new version. So I think, going to what Clayton's saying, there's going to be litigation on these very issues that, well, the guidance in October of 2020 is different than what they're saying now in August of 2021. And I relied on that when we decided to do the construction project at our hospital to put a new isolation room in for COVID patients. So I think this is going to play out over probably several years, in Clayton and Gary's arena. We'll see lots of litigation, lots of enforcement, and we'll kind of have to duke it out, with the government, to the very principles that Clayton mentioned before with respect to this, the guidance and the changes. I think this question will be, we've got a few more minutes and a couple more questions. I think these will be back to you, Amanda, with respect to the presentation with Tara. One question, do healthcare workers have to quarantine if exposed, since they are deemed essential workers if not positive or symptomatic for COVID?
So according to the OSHA ETS, if the employer or if the employee is notified of a close contact at work, they must quarantine unless the employee is vaccinated or had COVID and recovered in the last 3 months, and that employee is asymptomatic. If the employee is unvaccinated, then they must quarantine.
Okay. And then the next question, Amanda, this one's to you as well. If paying employees for COVID leave, does the government reimburse employer the same way they did before that expired September 30?
So according to my esteemed health or employment team, it actually took the team to make sure we had the right answer to this particular question. At this time, there are no federal dollars for paid leave. That additional reimbursed paid leave under the ARPA it ended on September 30th, and we are not aware of any new source of payment.
Okay. And then this one, I think, is also to you, Amanda. This relates to your presentation with respect to the provider enrollment. We, in our kind of our comments about, we're starting to see CMS look closer at our provider, applications, making sure we're keeping our information current and up to date. This question is asking, has CMS begun, or have you seen them act on not reporting ownership changes, so transfers of interest, strictly within the 30-day window? Or is this only in the case of a CHOW according to CMS rules like the tax ID change?
So I guess at this time, and Brooke, you do these as much as I do, I have not seen CMS get overly persnickety, I guess, about not receiving that within 30 days, but I never really want to run that risk because there is a statute and regulation out there that requires that it be done within 30 days. So, I mean, if you're outside of that 30-day window, certainly don't hesitate, I guess, in getting that change on file as soon as possible, but do your best to get it in within that 30-day window.
Yeah, I think I'd agree with that. I haven't seen the issue with CMS so much on the change of ownership side. It's been more on providers just keeping their information current, like the practice location example that you provided, making sure when there have been changes of board members or your managing employee that you get that information updated. I haven't seen so much on the change of ownership side, and that might be in part, and typically if Amanda and I are working with a client on a transaction, we typically send in the change of ownership packet before the transaction even closes, so that way we know if there's going to be an issue, and then we supplement with the bill of sale or the transaction document to close it out. So it would be pretty rare that we wouldn't file it before closing, so we don't want to be in that 30-day period. But I think Amanda's right. You need to get it filed as quickly as possible, and if it happens to be day 31 or day 35, I mean, you still need to file it. The other thing to look at there is to consider, well, is it really a change of ownership, which requires the 30 days, or is it really a change of information where you could argue you have that extra 90 days. And so that might be something to look at in that situation. And so I think we have one final question. Amanda, did we get any help on our last question?
We did not, our pinch hitter did not come in on that one. So
well, I hope
officially, I guess, stumped the panel.
I would say, okay, so I hope Wendy Brazel is still on from No Show. She has stumped the panel with respect to her question, which again came out of the COVID session this morning, where she was asking about a lease of space to the VA. Is that a contract covered under the EO, and what employees are covered in connection to that lease? I think, Amanda, you've coordinated with Tara, with other employment lawyers on our team. We just couldn't quite get it figured out before 3:30 today. So Wendy, if you need some additional guidance on that, you might just circle up with Amanda. We can get you connected with Tara, one of our employment lawyers, and we can try to work through that for you. But assuming you're still out there, kudos. If we were in live and in person, we probably would have had a candy bar or something for you. But kudos on stepping the panel. I think we've managed to cover the rest of the questions that were submitted. We were about 3 minutes over, so we appreciate everybody staying with us all day this afternoon and attending our Health Law Institute. And with any luck, by this time next year, we will be through COVID, and we'll be able to resume our in-person Health Law Institute. So with that, appreciate your attendance. You'll be getting that email with respect to a survey. Follow the information on your email from earlier today on how to get your CLE or other certificates for credit. And just thank you for attending.